Hi everyone, my name is Shazia Khan, and today's session that we'll be doing is managing employment relations and employment law, and we're doing learning outcome 2 today, which is to understand recruitment and selection legislations in a country. So firstly, what I'm going to do is I'm going to give you an overview of the last session that we did, which was learning outcome 1. And we looked at, in learning outcome 1, understanding key concepts in employment law in a country. So why employment law is so important, the relevance of the legislation around employment law, both for employers and their staff. We also looked at the element of how employment law in learning outcome 1 combats elements of discrimination and is there to promote equality at work. We also looked at what is meant by employment legislation and how it affects employees and employers directly, and what the aim of the employment law is, which is to provide equality within a workplace. We then went on to look at main features of employment legislation. So we had things like employment law, that legislation that relates to things like hours you work, discrimination, elements of health and safety, minimum wage, holiday entitlements, redundancy and dismissal, disciplinary procedures, training and development, and union rights. We then went on to look at the objectives, the whole purpose of having employment law in different countries, and what the relevance of that is and why it's so important for an employer to understand their responsibilities and an employee. We looked at the US employment laws, and we looked at the Fair Labour Standards Act, FLSA, which establishes elements of minimum wage, overtime, record keeping, and youth employment standards within America. We then went on to look in learning outcome 1 at Canada employment standards, and how they are protected within the province of Canada in regards to the federal laws in place, things like, hours of work, overtime rules. We then went on to look at the main points of Canadian employment law, things like minimum wage, that employers must be paid at irregular intervals, and also things like, vacation. We went on to look at the Combination Act 1800 in regards to elements of employment law and employment conditions in Canada. We then went on to look at the Equal Pay Act, along with the Sex Discrimination Act and Race Relations Act in the UK, and the importance of this and why they have been passed within the UK law and the relevance of this. We went on to then look under the Employment Act 1996, what an employer is. We looked at discrimination and referred to the case of Shamoon and Chief Constable of Royal Ulster Constabulary. We looked at discrimination on grounds of remedies for discrimination, unfair dismissal, and we looked at the case of W. Davies and Sons Limited and Atkins in regards to employees' dismissal. We then went on to look at the impact of regulatory and legal requirements on human resource policies in an organisation. So why it's so important that, the elements of HRA system are followed and laws and legislations are followed in practice. Things like Equal Opportunities, Discrimination Act, Sex Discrimination Act 1975, Race Discrimination Act 1976, Disability Discrimination Act 1995, the European Working Time Directive, National Minimum Wage Act and Data Protection Act, and Work and Families Act 2006. We looked at the regulatory framework in regard to government policies in regard to employment law, such as dismissal and redundancy, and employment law acts. We then went on to look at what ACAS was and how it helped employees, provided them a guide with any sort of elements of employment law. We then went on to look at the impact of ethical requirements and human resource policies in an organisation. So things like ethical issues could be equal opportunity, things like privacy, We looked at elements of compensation and skills, labour costs, and firing and hiring someone, and fair working conditions. We then went on to look at ethical practice in an organisation and why it's so important within any organisation to have ethical practice in place. We looked at the Institute of Business Ethics Research and how that supports and demonstrates and benefits organisations when they take elements of ethical values into consideration. We looked at ethics as a leadership imperative. We looked at key systems of HR, recruitment and induction, diversity and inclusion, learning and development, performance management, reward, including bonuses, incentives. We then went on to look at the purpose of the human resource policy and the importance of the policy, why it was relevant. So, things like to provide fairness, consistency, structure within organisations. We then went on to look at the development of workplace policies and why there was relevance, why it's so important to have workplace policies in place, things like, discipline, dress code, ethics, internet usage. We then gave an example of a number of legislation that was implemented within an organisation. The organisation we used in regards to this was the organisation, it was Tesco's. And we looked at their employment, labour standards, privacy and we then went on to look at health and safety regulations and human rights policies in regard to Tesco. We then went on to look at the element of HR policies in Tesco's and also looked at what policies they have in place and their legislation and the company, how they treat their employees with dignity and protect any sort of employees from any sort of harassment and takes action against anyone. So that was learning outcome 1 that we finished in regards to managing employment relations and employment law. Now we're going on to learning outcome 2, which is to understand recruitment and selection legislations in a country and why that's so important when we look at recruitment and selection. So firstly, we're going to go on to look at again on who is an employee. So an employee is a person who has agreed to be employed by yourself. So, someone who's agreed to work for some form of payment under contract law. So, it's someone who gets paid for the work they do. The workers don't need to be full-time. They can be considered employees. They simply need to be paid to work by an employer. So they will have an employment contract, which we'll look a little bit at later, and they are a person who's employed for tax purposes, and they will be either employed, self-employed, and there will be someone who would be getting a payment after the work. The case in regards to identifying if there was if someone who qualifies as an employee or not was the case of Caterham Cruises Limited and Williams and Ours. And in this case, it was in 1991, a French company acquired Catamaran Cruises Limited. The tribunal found that the company was a dire financial state and drastic action was necessary to avoid receivership or liquidation. The tribunal held that the financial condition did not justify imposing significantly different terms and conditions of employment on the employees. So the tribunal compared old and new employment contracts and concluded that the new terms were so unfavourable that the dismissals were unfair. Mr. Williams was initially told he would be self-employed when offered work in 1984, but was later considered an employee. The appeal by Caterham Limited was allowed. The case was not referred to a new tribunal, and the same tribunal would address the reasonableness of dismissal in light of employee acceptance and trade union recommendations. The element in this case was that Williams was an employee of appellants and thus within its jurisdiction. So it's sometimes difficult for company organisations to identify what an employee is, but within Employment Law Rights Act 1996, an employee is an individual who enters into a contract with the element of getting a payment. So discrimination is a really important element of Equality Act and Race Relations Act. The law, discrimination in the UK is that it's like that the law says that no one should be discriminated against, and discrimination which is against the Equality Act is unlawful. If experienced, you know, they can take an action against the employee under the Act. The Act is against the law for someone to discriminate because of a characteristic. So it can be sex, it can be race, it can be disability, it can be employment, education. It could be any forms of discrimination, and the main responsibility for discrimination at work lies with the employers. By law, all employers, and we've got the Race Relations Act, the Sex Discrimination Act, the Equality Act 2010. By law, all employees must make sure they do not discriminate against any employees or anyone else in regards to that, because there is protection for the law against that. About that, mine keeps muting. I don't know why. Sorry. So as we said, discrimination is really important, and the law protects anyone against any forms of discrimination, including elements of dismissal, employment terms and conditions, pays and benefits, you know, any form of recruitment redundancy. So discrimination at grounds on the element of sex, you know. So sex discrimination occurs when someone is treated unfairly for reasons relating to their sex. So although illegal in the UK for many years, the law is now incorporated into the Equality Act 2010. Sex discrimination continues to be an issue. For example, things like sexual and sex-based harassment are the area of pregnancy, which is a big element of it, and maternity discrimination remains serious problems, and low numbers of women in a senior role is a key challenge for many organisations. So, you know, sex discrimination is a huge part of you know, any sort of organisation, because it always occurs. It is where someone is treated unfairly, either because you are a man or because you are a woman. If sex discrimination takes place, you know, it is illegal, and you may take action, employment and training. So it could be because of a person's sex. It could also be because of a person's gender identity or sexual orientation. And as I mentioned, pregnancy is another element of it. So remedies available for the main form of remedies under unfair, this payment of compensation damages are awarded in respect of this. You know, if there's any sort of unfair dismissal cases in place, there are elements of compensation available. Unfair dismissal, and that is another element that's really important in regards to any sort of elements of unfair dismissal. You know, the fact that, you know, where someone is sacked in a way that is unlawful, you know, and every employee who has the qualifying period of service has the right not to be subject to any sort of unfair dismissal. If there's to be dismissal, an employer must show that the reason falls into one of the categories set out in the Employment Rights Act. 5 categories, as we mentioned. The employer lacked capability of qualification. The dismissal was a result of conduct of the employee, so such as things like dishonesty or poor attendance, failure to follow instructions, or any sort of gross misconduct. There was a genuine redundancy. The continuation of employment contravenes a statute. For example, you need to drive in your employment, but you are being banned due to speeding. And the final was it's some other substantial reason, SOSR. This can be on the form of personality clash. Just an example for your maternity leave. Unless your employer can prove one or more of the above 5 reasons, then your termination will be deemed to be unfair. So, the employer must follow the correct procedures. It's not something that you could just do like that. They need to follow the procedures in regards to employment. So recruitment and selection process, and this is really important process where we look at the element of that. And it's really important that when you, as an organization, to have a well-designed recruitment and selection process in place. And this allows organizations to both attract a wide pool of applicants and narrow the selection until you found, the perfect candidate for the job. So recruitment and selection, 2 key parts of hiring the process that allow companies to find the best talent they want. That is the recruitment process. So stage 1, you define the requirements. So that's through your job description, your job specification, and then you stage 2 is where you attract potential employees, so job advertising. And then stage 3 is select people, job interview, ability test. Selection is the process of assessing candidates' qualities, expertise, and any sort of experience, so that that is the best person for the role you've advertised. This process involves things like conducting interviews and using various tests and assessments to evaluate each candidate. So, employers would use tests in regards to trying to work out your ability and whether you are suitable for that job as well. An effective recruitment and selection process allows different companies to source, attract, and identify the best candidate for every open role. This can help to reduce any sort of attrition, increase productivity, and even improve the company's bottom line. So, it's really important that, within the selection process, you are there to find out how to, recruit someone, but use the right steps as well. Screening, things like looking at the CVs, identifying, whether they have the relevant experience, then, selecting the candidate. It's really, really, it's not an easy process because, sometimes you have to go through the rigmarole of, trying to identify whether the individual is capable for that job, looking at their CV and trying to get into place, collect the applications. Shortlisting is another thing that would be, an element of that. And then, holding interviews. It could be one-to-one interviews. It could be panel interviews, so where there's more than one person that will interview the candidate. Telephone interview is not conducted in person, but over the phone. There's also, they'll have tests, that, like we mentioned, testing allows any organization to see how the candidate copes under pressure. Its aim is to find out about candidates' true personality and abilities, not just what they say about themselves. So during the interview and the testing stage, candidates can be asked to do an assessment. And this could be done through a form of activities or role play or anything like that that would identify to the employer that the individual is capable for the job or meets the requirements of the job. So you'll have things like that selection process view. The diagram identifies initial screening, completed application, employment test. So it identifies elements of the process, but this is the best way to find the candidate for the job. Why does HR need to follow legislation for recruitment and selection? It's really, really important. The risk of not following this would be discriminating against someone. Also, it's important to follow the legislation and policies in place, because employment law exists to regulate the relationship between business and the employees. Now, by complying with relevant legislation, both employees and the staff members can ensure that hiring processes, dismissal process, and their workplace are fair for every individual. So, you know, it's really, really important. Especially in the UK, when we look at it, the legislation that is passed, we must follow that, you know, and part of UK employment law, things like recruitment selection, we must follow the legislation in place. You know, we must follow the Equality Act, we must follow the Sex Discrimination Act, and we should make sure that we are, you know, advertising jobs properly. We should make sure that we are not breaking the recruitment and selection process. So any sort of discrimination, we're not discriminating against anyone, because that's really important. You know, the most important piece of legislation, as we mentioned, is the Equality Act. The Act actually prevents employers from discriminating against employees and job applicants on basis of protected characteristics, be that sex, disability, race. So it's important that, you know, when we are looking at the process, we are taking into account all the legal requirements as well, and not discriminating against anyone. So it's really important that we, you know, do things like, you know, advertise widely, don't use information on social media profiles to influence decision on interview and recruitment, check the right to work, offer equal pay to individuals in the same role. You know, we you know, it's one of the, when we look at there are a number of employment slip-ups that organizations do, and they may not be intentional, but, you know, it's really important that discrimination law is in mind when going through the recruitment and selection process, and, you know, looking at the laws around it. So there are different forms of discrimination. So the UK has comprehensive anti-discrimination laws in place. Sex discrimination, we have the Race Relations, Disability Discrimination, 1995, 2005, and equal pay. And the government has progressed to plans to, you know, obviously implement these laws. And if there's any sort of requirements in regards to any sort of amendments to be added on, if the discrimination is increased, then, you know, legislation will play a big part in that. Sex discrimination. So sex discrimination is where when you are treated unfairly, either because, as I mentioned, because you're a man or a woman, or it could be your gender, or it could be your, you know, it could be the fact that, you know, it could be someone's sexual orientation. And the legislation applies to not just employees, but agency workers and independent contractors as well. So it's a big element of the laws relating to sex discrimination. And it could be, you know, sex discrimination in regards to it could be how they dress codes, you know, things like that. So elements of sex discrimination are so important. So sexual harassment is another element of can include things like, you know, verbal or written comments of a sexual nature, including remarks about an employee's appearance. So maybe how a woman dresses, if she wears a short miniskirt, comments, remarks made on that, questions about their sex life, or offensive jokes. You know, this is something that happens quite a lot within an organization, you know. Another one is propositions, advances, or making promises in return for sexual favors. Email, social media messaging with content of sexual nature. So, you know, it is illegal within any sort of workplace. sexual harassment occurs quite a lot within a lot of organizations, but it is identified as an illegal element, and is defined under the Equality Act, where it could be verbal or non-verbal. And as I mentioned, some examples could be like sexual posts on social media, sending sexually explicit emails could be one, comments on what they wear, comments on sexual nature, coercion. These are elements that could be identified. And sexual harassment is, as we said, recognised under Equality Act. And it is not necessary for the worker to show that the other person was treated more favourably. Employees are able to explain about behaviour. So employers will be liable for sexual harassment committed by their employees in course of their employment unless they can show that they took all reasonable steps to prevent this harassment. So it's really important, and it is part of the law. Types of sexual 2.1, evaluate the principles of discrimination legislation in relation to recruitment and selection. So we've got direct discrimination, we've got indirect discrimination, victimization, positive discrimination, and remedies in regards to that. So the first one we looked at is direct discrimination. And this is the obvious type, and the easiest to spot. Direct discrimination occurs when an employee is treated worse than someone of a different sex in a similar situation. So one of the ways this can happen is via job advertisements. For example, a job ad for a salesperson states that the role would be best suited to a man than a woman. There are instances when recruiting a particular sex is legal. Direct discrimination applies when any of the criteria set out by the Equality Act are met. In other words, it can occur when someone is treated less favourably because of their perceived sex or by association too. The next one is indirect discrimination, and this occurs when a workplace rule or practice disadvantages a particular sex. If the policy applies to all staff, it might seem like it's fair. However, this isn't always the case. The most quoted example of this in relation to sex discrimination is this. For example, a job role is advertised as requiring the employee to be 6 feet tall. This almost eliminates the possibility of many women applying. Much like direct discrimination, there are cases where it's legal to discriminate, usually on health and safety grounds, but more on the latter. An employee can only challenge a practice or rule if they're personally affected by it. So they must be personally affected. It's not just that they want to challenge it. However, when it comes to proving discrimination, they must show that others with the same protected characteristics are also disadvantaged. So it can't just be some element of that. Victimization, and this applies to an employee who's treated unfavorably for making a complaint or supporting a complaint about sex discrimination. If the employee is denied a promotion, fired, or subjected to abusive behaviour, this may be seen as victimization. We've also got harassment, which is a type of discrimination which can be broken down into 3 types. So the first one, unwanted conduct relating to a person's sex. So the result of this is a distressing, humiliating, or offensive environment for the employee, unwanted conduct of sexual nature, and then unfavourable treatment due to rejection of sexual harassment or because they're a victim of it. So the next one is positive discrimination. This is a form of discrimination that favours someone by treating them differently in a positive way. An example might be an organisation trying to appoint someone from an underrepresented group into a role considering whether they have the skills for the post. Positive discrimination is unlawful in the UK, primarily due to the Equality Act, which prohibits discrimination on the basis of various protected characteristics, as we mentioned earlier, such as race, gender, age, disability, and religion. Example of positive action for people at a disadvantage. So a construction company believes that employees with disabilities are disadvantaged in their industry. To help overcome this disadvantage, they decide to offer a mentoring scheme for disabled employees only. So that's a form of positive action. So whenever any so the next one is remedies. So whenever discrimination is found, the goal of the law is to put the victim of discrimination in the same position and he or she would have been if the discrimination has never occurred. The types of relief will depend upon the discriminatory action and the effect it had on the victim. For example, if someone is not selected for a job or a promotion because of discrimination, the remedy may include placement in the job or back pay and benefits the person would have received. The employer will also required to stop any discriminatory practices and take steps to prevent any forms of discrimination to occur. A victim of discrimination also may be able to recover costs, compensatory damages or punitive damages. So, you know, remedies could be available for the individual. 2.2, critically evaluate the role of contracts in employment law. So contracts are, an employment contract is really important within regards to employment law because it clearly outlines the obligations and expectations of both parties, including legally binding document for reference in the event of any legal disputes. And a contract is an agreement between an employer and employer which sets out, as we mentioned, their employment rights and their duties. What is a contract of employment? A contract of employment is an agreement, as we mentioned, between an employer and employee, is the basis of employment relationship. There are no statutory requirements to have a written contract of employment in its entirety, but employers are required by law to provide certain written particulars of the terms and conditions of the contract to the employee. This is known as a written statement of particulars. It is therefore common practice to have written statement issued to all employees to include the information of the identity of the employer. It could be things like place of work, hours of work, rate of pay. So these are elements that need to be considered when looking at a contract of employment, because in regards to that, that is the element of an agreement between the employee and employer in regards to a contract. And this would be made as soon as you accept the job. So if you start work, it will show that you've accepted the job on the terms, the date you've accepted the job. And it doesn't have to be in writing, it could be in verbal as well. You know, it could be written statements as well. So it's, you know, it's rights and responsibilities of the employer and the employee. So we've got the implied terms. So implied terms are terms that are not expressively set out in the contract and can be implied into an employment contract by common law or statute. There are several categories into which these fall. So employers might choose to rely on implied terms when the contract is silent, or whether it's imprecise on a particular matter. So broadly speaking, terms may be implied into the contract in certain ways. So firstly, terms implied by law. So these are often referred to as characteristic terms, as the law regards them as necessary characteristics of a particular type of contract. The next one is terms implied by custom and practice. So these are terms that are customary in a particular trade or locality at a particular workplace. Next one is terms implied or modified by statute. So here statute sometimes introduce rights which are enforceable as terms of an employment contract or terms implied by fact. And these may be situations when the contract between the parties fail to deal with an issue. In such cases, the courts will tend to consider if the term is implied in fact to reflect the intention of the parties at the time of the contract was made. An implied term may be of little assistance if an agreement lacks certainty. For example, if a contract imposes an obligation on a party to do something but does not specify how the obligation is to be performed, an implied term that performance should be reasonable will not give sufficient certainty unless there are objective criteria by which the concept of reasonable performance can be assessed, such as standard industry practice. Next one we'll be looking at is examples of terms that are implied into a contract, which I mentioned a little bit: the right to minimum period of notice, the right to duty of care, provide a safe place, equality, both men and women in regards to that, the duty to exercise reasonable care, the duty to be ready and willing to work, the duty to obey lawful and reasonable orders as well. That's an example of employees' implied terms. That's employees. And with regards to employers, implied terms, things duty to pay wages, health and safety duties, duty to provide a suitable working environment, things like duty to give reasonable notice, as we mentioned. So they're for employers. The UK's legal position. A contract of employment in the UK, in many aspects, no different from any contract in any country, because there's so many elements of that. You need to make sure that you are looking at providing any sort of elements of employment law within your workplace. It's so important that you apply the law and legislation. Types of contract. So as a business, the status of staff can take different forms. You could have employee, you could have a worker, and self-employed. There are differences between workers and employee. So workers have rights such as paid holiday, but they have fewer employment rights than employees. Workers adhere to contract terms, and in some cases they can hire someone else, like a subcontractor, or to do the work on their behalf. Types of workers include freelancers, 0 hours staff, seasonal workers. Employees carry out work personally and are legally bound by a contract. Examples of employees' rights are itemized pay slips, written statement of employment, fair dismissal. So these are types of workers that we have. It's elements of it. You have fixed term employment contracts, freelancers and consultants, 0 elements of contracts. So there are different types of contracts of different types of workers. So employee, worker, it could be, they could be on a fixed term, they could be on a temporary internship, 0 hours, like we've just mentioned. They could be casual. So further reading in regards to terms of a contract, conditions of employment, and there's links there that you could go to for CIPD members, and also question and answers on terms of conditions of contracts. And there have been much debate on the gig economy and zero tolerance, 0 hours contracts. So there's links there that you could go on to have a read around them. So that's further reading for you to do. Varying in employment contract, and that's another element of a contract that's so important in regards to trying to vary and change it. Varying any sort of contract is really important. A contract of employment, as we said, is an agreement between you and the employee. At some stage in your your employer, or you might want to change the contract of employment, and that's varying your contract. However, neither you or your employer can change your employment contract without each other's agreement. Changes should normally be made after negotiation and agreement. Changes to employment contracts could be made by agreement between you and the employer. Collective agreement. This is a negotiation between your employer and a trade union or staff association. Employers sometimes need to make changes because of economic circumstances. There are some reasons. The business may need to be reorganized, so move to a new location, or may need changes because of new laws that have been implemented or regulations have been put in place. Things that might change, it might be rates of pay. So the rate of pay may change. Working time, the working time, for example, longer or shorter times, duties and responsibilities, or the location where you work. Agreed changes not necessarily have to be in writing, but if they alter terms in your written statement of employment particulars, then your employer must give you a written statement and shows that changes have been made. If the employer wants to make changes to your contract, they should consult you as a representative, which is a trade union. They cannot just do that themselves. Your employer isn't simply bring in any change they wish. If the employer tries to bring in their change, they don't agree, you need to obviously put in your objection in writing, but also identify why these changes have made, and legal actions can be taken for this. Employers who wish to alter existing contractual terms have three main obligations. Firstly, to agree the changes as we mentioned, make changes unilaterally, and terminate the employer's contract by notice and offer them re-engagement on new terms and conditions. Any variations should be confirmed in writing within a month. So if there's a contract that needs to be varied, agreed necessary changes should be made in the written statement of employment particulars that we mentioned, and it should be made within 1 month of the changes taking place. So if there's any sort of additional points to consider, whether they need to scrap the whole entire contract, if there's any terms being made, if there's any changes to be made, it's really important that this changes is variation of contract is discussed between the employee and the employer. So legal remedies in employment contracts. So legal remedies, the employer has to treat the employee as if the dismissal has taken place. So, there are various legal remedies. The first one is reinstatement. This is an order for reinstatement that the employer shall treat the complainant in all aspects as if he had not been dismissed. So the impact of this is huge, and the employer, the original contract is reinstated and they take the job up, they're held before the dismissal, and the same terms are applied here. So, it needs to be followed in regards to and this is a remedy that an employment tribunal may award to the employee if it finds that they have been dismissed unfairly. So it's quite a good remedy to have in place. The next one is re-engagement. So this is where if a contract changes if a contract change has not been agreed, your employer may propose to introduce the change of dismissing and rehiring. Some people call this fire and rehire, or dismissal and re-engagement. So this is an element that needs to be taken in place when looking at making changes to the contract. The next one is compensation, and compensation in the form of discrimination is the most common form of remedy that can be made against the employer or the discriminator. Awards can reflect the pecuniary loss suffered, injured to the feelings, and aggravated damages to the employer's actions. There's payment of compensation as well as damages, and damages may be awarded in respect of patrimonial losses suffered, and compensation is monetary relief for any forms of discrimination within the workplace. So in conclusion, without this legislation, laws to govern what happens in the workplace, employees would be left with like in a hostile situation, and they'd be left being treated unfairly and discriminated against. Most of the laws in place are there to protect both the employees and employees with taking advantage. Things like Employment Rights Act, Sex Discrimination Act, Race Relations Act. So, you know, they are there to protect both employers and employees. And if there was no laws in place, then people would suffer and employees would suffer a lot. 2.3, analyze the mechanism for establishing contracts of employment. So key elements of employment contracts are hiring new employees, although this is not mandatory, into a written contract. As a minimum, employees are obliged to give employees written particulars of the main terms and conditions of the contract. You know, it's really important that it's a legally binding contract, that they give them a particulars of the contract, the work schedule. So the contract must have will comprise of, as we mentioned earlier, express and implied terms, and the, you know, termination and notice periods, disputes, any sort of redundancy, confidentiality. The contracts must contain it's a detailed contract in regards to what is required of the employee, and the employer. So contract of employment, which, as we mentioned earlier, I must have the probationary period, notice period, benefits, confidentiality, termination, and post-termination restrictions. Express terms. So Section 1 of the Employment Rights Act 1996 requires employers to issue employees with written particulars, as we mentioned earlier, of the main terms and conditions of their employment. So express terms, specific terms that are usually put in writing, for example, the employee's pay or working hours. And, you know, it's really important when it comes to it. An express contract requires that the elements are specifically stated, including the offer, acceptance, and consideration. They are elements that mutual assent, capacity, and legally accepted terms. Example include like employment contracts and even contracts to perform a service. So it's really important when we look at our express terms, the importance of identifying them when it comes to employment law. As we mentioned, express terms are agreed earlier, as we mentioned, in writing or verbally at the interview with your employee. However, some express terms may be put in writing, as we mentioned, in the written statement of particular. Essentially, this will be the document containing the main conditions of the employer's employment with you, and also additionally some express terms typically find in writing things like job title, pay rate, as we mentioned earlier, working hours, sick pay, notice. And to get more on elements of express term, refer to page 7 of the UK Employment Guide for more details, which the links are in the reference list. Implied terms, as we mentioned earlier, are another element of employment contract, and they're terms that should be evident to both you and the employee. For example, the understanding that an employee should not steal from you, or that they must be polite when dealing with clients. You can think of implied terms as the silent terms of an employment contract. Indeed, they exist the moment both parties enter into a contract. Additionally, you may have implied terms in your employment contract through customs and practice, like I mentioned earlier, through the laws, and to demonstrate what you both intended in the employment contract. Despite implied terms of an employment contract being obvious and silent, they are still essential to ensure a good working relationship between the employee and the employer. Sometimes they are in place because they are needed and there is no express term on the subject. An implied term is an employment contract and obvious terms. There's no need to write them. However, it's still good practice to clarify the rights and obligations. For example, you may decide to write them in employee's handbook. So, you know, it's really important to identify to the employee where these are. And we looked at implied and express terms earlier. This is just to reiterate that. Varying terms. This is, as we mentioned, it's really important part of the contract where you can vary the terms, so you can amend the contracts. And you know, if there's a need for change, so if the legislation has changed, you can make notification in writing, or you know, there's different ways to change the contract. But you know, you must, when contracts are changed, you know, it needs to be done with both the employee and employees together, so that they are aware of the changes to the contracts. Any employee cannot make changes to the contract because the employee may refuse to sign that contract because, you know, they may have not been there when they wanted to make changes. They would receive a new written statement, a full written statement of the employment in particulars. So, you know, they have to identify what, you know, what the changes are. And they both need to be at the meeting for this. And that's the element of varying contracts. So changes need to be made, but both with the employee's consent, as I said, and both need to be there. You know, if an employee makes significant change to an employee's contract, then, you know, that's a breach of contract. It's a constructive dismissal. Legal action can be taken for that because it's a breach of contract and it wasn't agreed by both parties. These are some of the references that have been used that you can refer to. There's links there that you can refer to in regards to these references. Make sure you have a look at these references when looking at certain elements of, you know, contract employment law or contract law in regards to implied terms or anything like that. There's links there as well, links to websites that you can go on to look at human resource management. And the fundamental in regards to terms of a contract, so implied term, express terms, looking at remedies that may be available to them. So you can go on to the links there. If you, so we finished learning outcome two now. If you have any questions that you need to ask or email, you could email me or you could email learnerwork@ukvarsity.co.uk. If there's no questions, thank you for attending today's session. And the next session is learning outcome 3. Thank you.